So I won't go back and repeat that great introduction I did. We'll pick it up from here. We have, so I did the introduction. So this is going to be more of a presentation style webinar. We still will have time for questions and answers at the end. So I'll direct everyone down to that Q&A icon. For those of you that submitted questions in advance, thank you. That helped drive some of the content that has been put into the presentation. So we'll be able to answer a lot of those early questions that came in. So with that, I think those are the housekeeping details. Feel free to submit questions anytime during the presentation. We are going to wait to the end, however. And with that, I will throw it over to our Chancellor, Domenico Grasso, to kick us off. Domenico?
Thanks very much, Ken. I want to welcome everyone to this very important presentation and town hall conversation. This is on a topic that has received a lot of attention in the press over the last several years and is very important to us. For those of you who know me well, you know that I am a fierce supporter of UM-Dearborn, and I typically wear the Block M enhanced by the Dearborn logo underneath. But today, I decided to wear just the Block M, the unadorned Block M, because this policy applies to the entire campus. This is part of the whole University of Michigan ethos as to how we're going to deal with sexual and gender-based misconduct. This also applies to universities across the country. So I even thought about acquiring a sweatshirt like John Belushi had that just said college on it, because it applies to all colleges. But then I thought Animal House was the epitome for sexual misconduct, so I didn't want to promote that at all. So we don't have that on here at all. So, but I do want to say that this is, all kidding aside, this is a very, very important topic. This type of sexual and gender-based misconduct has no home on any of our campuses. We have two outstanding presenters today, two great attorneys that have different roles at the university. Pam is on our campus, but spent a lot of time on the Ann Arbor campus. She's our director of the Office of Institutional Equity, and Patty Petrosky is Deputy General Counsel. And I had the pleasure of listening to Patty present this to the executive officers, and she is incredibly knowledgeable about this subject. And I don't think there's anybody in the United States who knows more about this than she does. So I won't delay this any longer, because we're here to hear the details about this, but I'll turn it over now to Pam to start the program. Pam?
Thank you, Domenico. I appreciate that. So let me just tell you a little bit, if we can move to the next slide, what we're going to be talking about over the next hour. We'll start off with a little bit of a background as to how we got to the point of the policy that became effective last Friday. Then we'll talk about what that policy contains. We'll walk you through the procedures that accompany that policy. We have a set of procedures for students, and then we'll do an overview of the set of procedures that we have for employees. That also applies to third parties, and then we'll leave some time for Q&A at the end. I also want to thank everybody who had a question that they submitted with their registration. I recognize for some of you, you might not have had a question yet. But we did try to embed the responses to your questions in this presentation. But if you have a question while we're talking, type it in and we'll try and get to it. So moving on in terms of the background. So there were really two things going on over the past couple of years. One of them was internal to the university, and the other one was an external force happening through the Department of Education. So in 2018, kind of moving into 2019, all three campuses underwent an external review in terms of how it addresses sexual violence matters. And there was a universal recommendation that the policies and procedures that we had for addressing these matters were a little bit split up in different places, and they thought it would be helpful if we brought them all together into one place. Around the same time, in November 2018, the Department of Education proposed some new Title IX regulations. Of course, when a regulation is proposed, they then send it out for feedback to the community. So they issued them, they sent them out for feedback. You're not entirely sure if what you get at the end will match up with what was proposed. So then In January 2019, President Schlissel appointed a task team comprised of members of all 3 campuses to work on the recommendation from the external review that we create this, we refer to it as the umbrella policy. Patty absolutely is knowledgeable, and she was chaired that committee and did an excellent job doing that. And then, like I said, there were people from all 3 campuses that came together, and we began that work in earnest. And we then created a draft that was approved by the EOs, and we wanted to present it to the campus community so that we could get your comment. At the same time, we kept being told the final Title IX regs are going to be issued any day now. At the end of the day, you get to a point where you just want your own campus's feedback. We couldn't wait any longer. And so we sent that draft policy out to you for feedback. Some of you might remember that. If you've submitted comments, we sincerely appreciate it. And that process took us through about December 2019. Then in January, it says January, February 2019, I think it was 2020. Typed that wrong, sorry. The task team then reviewed your feedback. We had great feedback. We feel at the end of the day, we ended up with an even better policy as a result. And we finalized our internal draft umbrella policy. We kept being told those Title IX regs are coming out any day. Ultimately, as shown on the next slide, they did come out in May 2019. Unfortunately, they were significantly different than the proposed regulations, and there was a very short turnaround time. The Department of Education said you have to effectuate these regulations by August 14th, 2020. So over the next few months, Patty pulled our team back together into action to align the draft policy that we had finalized with the contents of the Title IX reg. We did that, and that policy and the attendant procedures were issued and made effective on August 14th. So I'm going to tell you a little bit about what was new in those Title IX regulations. Some of which might be concerning, but I don't want to alarm any of you because these were all things that the task team addressed, as we'll talk about later in this presentation. So the first thing is that the definition of Title IX was narrow and narrower than we had ever used as an institution. And they also really restricted when an institution is required to respond to a sexual misconduct concern. So for example, if the institution had the information, but that information wasn't held by a specific person like me, or the chancellor, or the provost, or a dean, there's no institutional obligation to respond. Obviously, that's not consistent with how we operate, but that's what the Title IX regs say. And Patty's going to talk a little bit more about that later in the presentation. We're also required to dismiss certain matters. So if, for example, a student came to us with a concern about something that happened when they were engaged in a university program, but it was outside of the United States, even though it was our program, I'm required to dismiss that complaint. Again, we were aware of it, and we've worked around that to make sure that those cases are addressed while still being compliant with the regulations. And then these procedures also have a highly prescribed process for how we have to address complaints that meet the Title IX definition, including a live hearing with cross-examination conducted by a university-provided advisor and an opportunity to appeal. So I know when people think about Title IX, when they think about sexual misconduct, they think Title IX, but there are really other laws and federal regulations out there that apply. One of them is Title VII. And although we have to comply with Title IX, we also have to comply with Title VII. And Title VII has a broader definition of sexual harassment than the Title IX regulations now do. And it also requires us to respond when we knew or should have known about sexual misconduct, not just when certain people hold the information. And it doesn't require that we use any specific process. Another highly relevant law is the state of Michigan's Elliott-Larsen Civil Rights Act. That law has consistently in the past been interpreted consistent with Title VII. So with that information, the task team then got to work to revise the policy. And we did that to make sure that we were acting consistent with Title IX regulations, that we were still able to meet our obligations under the broader Title VII and Elliott-Larsen Civil Rights Act. And we were also able to respond in a way that's consistent with our institutional values, what we expect of ourselves, what you within our community expect of us. And so we worked to try to do that, and now we're going to tell you ultimately the policy that we arrived upon. So I'm going to pass the baton to Patty to talk to us about a high-level overview of what's in the umbrella policy.
Thanks, Pam. Good morning, everyone. Thanks so much for having us today to talk about this very important new policy and procedures. The one thing that I want to make clear at the outset is that this policy and procedures apply on all 3 campuses, Michigan Medicine, and they apply to students, faculty, and staff. So for the first time, the university will have a common set of definitions that everyone is operating under. So one of the common questions that we are asked is, why does this only relate to sexual misconduct? Why aren't other forms of discrimination, whether they be racial, disability, age, etc., why don't they have similar rules? And the short answer is that the law, for better or worse, treats sexual misconduct differently, treats sex discrimination differently than other forms of discrimination. And so that is why this policy pertains to sexual misconduct only. Now, one of the things when I'm talking about this that I try to explain to people is what the regulations have really done. If you think of it as a pie chart, this is all forms of sexual misconduct in a circle, a big circle. The federal government has said for a sliver of that, not the entire circle, but for a portion of that, which we define, the federal government has defined, and I'll talk about that a little bit more. Universities, you need to provide very highly prescriptive procedures. For everything else in that circle, you can do whatever you want. You can choose to regulate it, but you don't have to. And how you regulate it is left up to you. That will become very important as we talk going forward, because what the university has decided to do is to continue to regulate all forms of sexual misconduct, and we provide highly prescriptive procedures for that which we are required to do, but we do continue to regulate all forms. So let's talk a little bit about what that means. The policy pertains to sexual and gender-based misconduct. Those are the broad types of prohibited conduct. It also adds a definition for Title IX misconduct. Now, Title IX misconduct is defined under the regulations. And in particular, as Pam alluded to, it includes a new, narrower definition of sexual harassment. And it also includes dating violence, domestic violence, stalking, and sexual assault as defined by the Clery Act. It goes further, however, and says that this type of conduct must take place in a university program or activity, and it must be directed against a person in the United States. This gets a little complicated, but let's use a practical example that will help to flesh this out a little bit. Let's take an example where a student is sexually assaulted on Dearborn's campus. That would fall under Title IX misconduct. Let's take an example where the student is off campus and sexually assaulted, maybe just a few blocks at a private apartment or house. That would not be Title IX misconduct as defined by the regulations, because it's not occurring on campus or as part of a program or activity, but nevertheless, that is still something that the university has chosen to regulate. Similarly, because it must be directed against a person in the United States, if a student is on a study abroad program and is sexually assaulted, that would not constitute Title IX misconduct because it has to be against a person in the United States. However, the university has said that would still be a form of sexual and gender-based misconduct that we would continue to regulate. So this slide kind of helps to show what sexual and gender-based misconduct is. So you'll see the broad definitions of all of the different types of conduct that are included. And then Title IX misconduct is a subset of that. Again, it needs to meet certain jurisdictional requirements. It needs to be part of a program or activity and directed against a person in the United States. The umbrella policy identifies confidential resources. Confidential resources are resources where students, faculty, and staff can go to speak with someone privately. The person that they are speaking to, people that they are speaking to do not have a reporting obligation. This is very important because when you're trying to weed through what your options are under a stressful situation where the policy may seem complicated, people in these areas can talk to you on a confidential basis, help to outline your various options, and talk to you about the pros and cons from a personal perspective of pursuing various options, and help you make a fully informed decision about what to do going forward. So the umbrella policy also outlines places to report. And if you, I want to make clear that everybody understand the outset. The university is required to take action when it becomes aware of this type of conduct. It's required to investigate and adjudicate these claims when we have someone who wants to go forward with the process. And so to file a report or a complaint with the university, you should talk to Pam Heatley, and outlined on this slide is how exactly you can make that report. If you want to file a criminal report with local law enforcement, you can contact the Department of Police and Public Safety. And again, here's the contact information on there. They are two separate processes. They often work in parallel. But for someone who has experienced sexual misconduct, they can choose to report it to the university, to law enforcement, to both, or to neither. One thing that I want to talk about that has received a lot of attention in the past is who on your campus has a reporting obligation. In the past, we've talked about the concept of responsible employees, and a lot of effort has gone into trying to train individuals at the university who are responsible employees. Under the new regulations, the concept of responsible employees is gone. And instead, the regulations refer to officials with authority. And for some of you, you may have read in the newspaper that the federal government has effectively narrowed who on college campuses could be required to report. As a technical matter, that's true. The university could have decided that it wanted only a narrow subset of administrators, faculty, and staff to be individuals with reporting obligations. But instead, we have decided to keep a much broader list in keeping with what we feel is consistent with our institutional values and obligations. So an individual with a reporting obligation must share the details of prohibited conduct with OIE within 48 hours of learning about it. And if they fail to do so, they may be disciplined for not reporting it. All other employees are encouraged to report, but only individuals with reporting obligations have an obligation to do so. So, as I mentioned, there are two categories of IROs. Those include both officials with authority, as identified under the new Title IX regulations. These would be people like Chancellor Grasso, the president of the university, executive officers, vice chancellors, deans, department chairs, and head coaches for varsity athletics. And the other group are individuals, other individuals who had historically been responsible employees. These include all vice and associate executive officers, chancellors, academic and staff supervisors. So these are employees who have the authority to hire, fire, transfer, suspend, lay off, promote, discipline employees, student life staff members, your Department of Police and Public Safety staff members, HR staff members, individuals who accompany students on a study abroad program. And essentially, there's only one difference between these two categories of people. The people who fall into the officials with authority category, they are always on. It doesn't matter how the information comes to them. So they may be on a beach in Tahiti vacationing, and someone comes to them and says, I have been sexually assaulted. They have an obligation to report that to Pam as your Title IX coordinator. For all other IROs, the report must be within the scope of their employment. So if they are at a football game in Ann Arbor with their neighbor, and their neighbor tells them that their son or daughter had experienced sexual misconduct, they don't have an obligation to report. They're encouraged to report, but they don't have to do so. And what I would say to all of you is that if you have any questions about this, please call Pam. She is a national expert in this space. When the new regulations came out, she was chosen by our professional association to give a presentation describing, explaining them. She's very familiar with them, and she can help you navigate what can otherwise be perhaps an intimidating or complicated network of different policies and procedures. So this just sets out individuals who are officials with authority. Again, these are the people that I just outlined. These individuals are always on. And here are all of the other IROs. And so there are a couple of exceptions to this. What if someone in the context of a classroom discussion who's been asked to describe a very personal experience talks about being sexually assaulted? That would be an exception to the reporting obligation for people who are not officials with authority and are not considered always on for purposes of reporting. Here are other IROs that we just talked about. And with that, I'm going to shift briefly and talk about the procedures. And please keep in mind, we're trying to pack in a lot of information in a very short period of time. Pam or I could talk about any one of these subjects for hours on end. If you have questions, we encourage you to ask them. And if we don't have time to get to your question, reach out to me or Pam separately, and we'd be happy to talk to you. So I'm going to talk for a few minutes about the student procedures. But before I do that, I just want to make clear that the procedures the university employs are dependent upon who the respondent is. And so, as a preliminary matter, one of the questions that we're often asked is, can you do anything? And it really depends, what is the relationship of the respondent to the university? Can we exercise any control over them? So if it's a student respondent, it will typically fall under the student procedures. an employee respondent, the employee procedures, and a third-party respondent, again, under the employee procedures. And when we talk about a respondent, we're really talking about someone who is accused of having committed the sexual misconduct. So I want to talk about the student procedures. First and foremost, it's important to understand that the university would very rarely move forward if a complainant does not want to move forward. We only do that in a very limited number of cases where there is a direct threat to the safety of the university, and or we know that we are dealing with a potential serial respondent. And so when a student comes forward and says, I want to know what the options are, what the processes are under the university procedures, there are generally two. The first is adaptable resolution. It is an informal resolution process that does not result in formal discipline against the respondent. Instead, the respondent and the complainant come forward and work with a very skilled facilitator to talk about what has happened and to get the respondent to accept responsibility for some of the harms that have been caused to the complainant, to acknowledge some of those harms, and to agree on appropriate steps moving forward. Typically, these might include educational measures that the respondent is required to do, and all of that would formally be documented in an agreement. The other option is an investigative resolution, which is really comprised of an investigation, a hearing, and a potential option to appeal at the end. Now, this is a very scary slide, and I appreciate that some of you may not be able to read all of the nuances. You can go to the OIE website to find this slide, and if any of you have any other specific questions about it, you can talk to me or to Pam about it. But in essence, under the student procedures, there are a number of different phases. A complainant would meet with Pam. Pam would outline the options, and if a complainant says, I want to move forward, there will be a number of different phases. The first is an investigation, where Pam would gather up the relevant evidence, talk to the parties, talk to any witnesses, look at any physical evidence that might exist, text messages, emails, sometimes there's video, and they will issue a report summarizing the evidence that has been gathered. At that juncture, the case moves to a hearing. Now, under the regulations, we are only required to provide a hearing for Title IX misconduct. So again, I'm showing you the diagram, the pie chart. We are only required to do a hearing for the sliver that constitutes Title IX misconduct. However, we are in the Sixth Circuit, which means we are in a legal jurisdiction that requires us to provide hearings in student sexual misconduct matters. As a result, the university has made a decision that for cases involving student respondents, we will always have a hearing in an investigative resolution. So after that investigation, there is a pre-hearing meeting and then a hearing. And some of the notable aspects about the hearing are that there is an opportunity for cross-examination. Historically, this cross-examination has been done by students, which is what the court allowed us to do. Pursuant to the regulations, however, the cross-examination will now be conducted by an advisor of the student's choosing. The advisor may be an attorney, but does not have to be an attorney. However, if the student does not have an advisor, the university must, pursuant to the regulations, provide one for them. And the university has decided that in student sexual misconduct matters, we will be providing an attorney for those students who do not have an advisor to serve as their advisor at the hearing. The attorney's sole responsibility will be to conduct the cross-examination of the other party and the witnesses. They will be provided when the investigative report comes out, and once the hearing is over, that advisor will no longer have any obligations. Following the hearing officer will issue a notice of hearing outcome, and there are options for the parties to appeal that outcome should they choose to do so. And with that, I'll turn it over to Pam to highlight a little bit about the employee procedures, and then hopefully we can get to some Q&As.
Right. Thank you, Patty. So in terms of the employees, going all the way back to when I was discussing background with you and some of the legal drivers that are out there, there are times that if the university learns of sexual misconduct alleged to have been engaged in by an employee, we have to act. On the student side, if someone raises a concern about a student, unless there's a significant safety concern or some other significant factor, if a complainant doesn't want us to move forward, we aren't required to, and we've created space within our policy where we have the option to not do that. On the employment side, we don't. And I've mentioned that twice now because it's important, and I want our community members to understand that, because as much as I want to be able to address any sexual misconduct that happens within our community, I also really want to respect individuals who've experienced that behavior, who might want help but don't necessarily want to initiate a process at that time. So in a few minutes, I'll talk about where you can go to get help confidentially without necessarily starting a process. But if the concern is about an employee, and either I or one of the individuals with reporting obligations receive a report, we will move forward with it. And within the employee procedures, we have two tracks that we follow. So I loved Patty's showing of the circle. So we have one track for that narrow slice of Title IX behavior, and then we have another track for everything else that we choose to continue to address as an institution. I'm going to show you a chart. It's scarier than the one you saw for students, but I'll explain it. Can we go to the next slide, Patty? And again, I recognize that you're not going to be able to read this necessarily, but I still think it can be helpful to have a visual. This is on the OIE website. If you go on the website, on the left-hand side, second tab down, it says reporting sexual and gender-based misconduct. If you click on that link, you'll see this about midway down the page. If you can't find it, just email me. I'll send you the link or a copy. So in terms of the process, for most of those cases that aren't in that narrow sliver of Title IX behavior, the process is the same to the process that we have been using for employment matters, that's consistent with how we address other forms of alleged discrimination by our employees. And that is that we conduct an investigation using a process very similar to what Patty mentioned for the student process, where people are given an opportunity to review their own statements. They review all of the evidence that's gathered before any decision is reached. And at that point, if there isn't Title IX misconduct, it goes to this process that you see on the left, which is that I make a decision based on having conducted that investigation as to whether the university policy was violated or not. If it wasn't, the matter is concluded. If it was, whatever university official is responsible for that area will determine what type of institutional action is necessary in order to address the situation. And then the employee who's impacted, if there's disciplinary action taken, always has the option to grieve under our existing grievance procedures. That's a process we've had in place for a long time. Hopefully that sounds familiar to many of you. If the behavior at issue encompasses Title IX misconduct, that strict definition, even if it also includes sex and gender-based misconduct, we will put it through the process on the right, the Title IX misconduct process, which is similar to the process that we use for students in the sense that it will go to a hearing. The hearing officer will, in holding that hearing, there will be cross-examination. The parties involved can bring their own advisor. If they don't have one, the university will provide one. That advisor conducts the cross-examination. The parties never cross-examine one another. And then the hearing officer determines whether the policy was violated or not. Either party can appeal the finding. At the end of the day, if there's a finding that the policy was violated and disciplinary action was taken, the employee still has the option of using our existing grievance procedures if they want to grieve any disciplinary action that has been taken. So that, in a nutshell, is our process. An important thing that on the next, one other thing I wanted to add, I didn't want to leave out, is we do have one other thing under the employee procedures, and that's mediation. And we cannot make mediation available when a student is bringing a complaint against an employee, but we do occasionally make mediation available when an employee has a complaint against another employee, or there's a complaint involving a third party. If it's appropriate to the case, it's completely voluntary. We would never require anybody to use mediation, but that's also built into the procedures. So moving forward 2 slides. Underlying all of this is a support structure. And thanks, Patty. And we offer supportive measures in all cases. And it can either be offered through me, if people are willing to communicate with me, particularly when employees are involved, knowing that it would prompt some institutional action, or supportive measures and support can be sought from confidential resources that we listed above. For students, those are CAPS and the Student Ombuds, and for employees, it's the Faculty and Staff Consultation and Counseling Office, FASCO, and the Faculty Ombuds. Those offices are confidential places to talk about your concerns, as Patty mentioned, but those offices, other than the faculty ombuds, can also provide supportive measures. For example, I'm a student who's just experienced some form of sexual misconduct, and I have an exam today, and I don't think I can go in and take that exam. There may be a way that we can support that student as a way of helping them get through this moment, and also provide supportive measures down the road to help them remain engaged in our community, academically successful, regardless of whether they choose to file a complaint or not. Obviously, we would always want to address the underlying behavior, but we recognize that in the moment, that's not always right for a person. And hopefully, if we continue to support them, we will learn of what the behavior is and can address it. But whether that ever happens or not, this is our community member that we want to support. And so we have these measures in place. And I think it's important that everybody in our community knows you don't have to file a complaint to get help. We will help you. One area that changed in this realm from our previous procedures is that we used to always also provide what were called protective measures, which were we took actions that also impacted the person a complaint had been brought against. Now, even if a complaint is brought, we cannot take actions that seem punitive towards a respondent. So most supportive measures are for the complainant and don't necessarily have a direct impact on the respondent, although we still can do things like direct the parties not to have communication with one another. So what's next? We've issued the policy. We've started now helping our community to learn about these policies so that we all understand them and have a common understanding. I'm sure any of you who are individuals with reporting obligations or think you might be probably want to know more. We are working to get a program together and out to you. In terms of the work related to the policy and procedures, the task team is already talking about and setting up a structure for getting your feedback. That's part of the reason why the university issued this as an interim policy, because we realized we hadn't heard from you, and what you have to say is incredibly important. So the task team will be going out starting in the late fall and into the winter semester to hear from you. We'll do it with certain groups again. We'll also issue an electronic means so that any person can provide feedback to us, and we really encourage you to do that. It was very helpful last time. And then we do hope to have the policy finalized in final form in July 2021. So that was what we had planned to share with you, but now we would like to answer your questions.
Thank you, Pam and Patty. So we have a handful of questions that have come in. I would like to remind all the people on the webinar, if you have a question, use the Q&A icon at the bottom of your screen. So I will just go ahead and start going through these, and you can decide who wants to answer. So the first question is, are all of the resources shared across all 3 campuses? In the previous sexual misconduct training, there were not very many resources listed for Dearborn.
So I can answer that one. Formally, no. We have our resources on Dearborn. We have worked over the past few years to expand those resources, and we're also looking to expand them further where we can. Informally, there are times when individuals come to me and they need resources beyond what we might have immediately available. And so either I or one of our confidential resources arrange to get the person resources that are helpful to them. Sometimes it's a resource within the community. Sometimes we pull on a resource from another campus, but we do what we can do to get the person what they need and what will be helpful to them.
Thank you. The question about timing. So is the 48 hours calendar time or business hours time? For example, if someone were to find out at 4 p.m. Friday and they don't report something until 9 a.m. Monday, is that a violation?
So it is calendar time. It is not business time. This is an issue that our task team grappled with, and ultimately we had a lot of concerns that simply saying reporting as soon as possible might not be sufficient. So we wanted to provide some guidance to employees. Now, if you get a report at 4 p.m. on Friday, you know, I would encourage you, if you know I have to report this, I would encourage you to contact Pam. You can also fill out a reporting form electronically. That is the manner in which most individuals with reporting obligations report. If you don't know whether you have a reporting obligation, if you are aware of information that you think should be reported, then I would encourage you in those situations to reach out to Pam or me and kind of talk through the situation, and we can offer you some guidance on that.
So maybe a question for Pam. So where would that form be found?
So it's on the OIE webpage. If you click on the reporting sexual and gender-based misconduct, you can use the form that's there. In addition to that, you can email me, you can call me. I recognize, given the way our campus community operates, normally someone would come to my office or they might pick up the phone and call. That's a little bit harder to do now, but email would be perfectly fine. There's no magical way of getting this information to me. Anything that seems reasonable in the moment is sufficient. And I would also say, if you're not sure that it's something that you have to report, you can email me and say, hey, I have something, I'm not sure if I have to, can we talk about it? And we'll connect and walk through it.
I think that's great advice. If you don't know, ask. Nothing wrong with asking questions. Next question, are academic advisors IROs if he or she is not a supervisor?
I can take this. The short answer is no. So if you are an academic advisor but don't have another position that might trigger a reporting obligation, so for example, you don't accompany people on study abroad programs, or you're not a coach for a club sport, then you would not solely as an academic advisor have a reporting obligation. You are not considered to be an IRO.
And I'll add, I'm not sure if we have academic advisors in student affairs. If we do, our employees in student affairs are IROs, so they would have a reporting obligation.
Thank you. Next question, does Title IX define and cover gender identity and sexual orientation? If not, what laws cover gender identity and sexual orientation?
I missed the first part of the question there, Ken. So if I don't actually answer the question, just let me know. But I can tell you that our policy, this particular policy we're talking about today, does cover not only sexual misconduct, but also gender-based misconduct. We didn't talk about it quite as much because we were focused on sexual misconduct. But yes, it would cover discrimination on the basis of sexual orientation. It would cover discrimination on the basis of gender identity, gender expression, and also harassment on those bases.
This next question, it's interesting to me. So events organized by campus staff that bring awareness to sexual assault and domestic violence, are staff and teachers required to report if in attendance when a student shares a past experience? So I'm interpreting this.
Yep. Yeah, I've got it. I know what they mean, and I've got it. Let me start by saying it depends on, one, are you an individual with a reporting obligation? And two, are you always on? Are you an official with authority? Or do you fall into that bucket of other individuals with reporting obligations? If you are always on, so if Chancellor Grasso attends a Take Back the Night event on your campus and you have survivors who come forward and tell your stories, he does have an obligation to report that. And so what I would encourage any official with authority to do who plans to attend those events is to talk about their reporting obligation at the outset. Now, if you fall into the other category of IROs, so these are supervisors, student affairs, athletics, HR, etc. If you fall into that bucket, you do not have that obligation because you are not always on, and arguably this wouldn't fall under the scope of your authority. Now, I know that this is complicated. Under prior guidance that we've received from the federal government, there used to be a blanket exception for public awareness events like Take Back the Night. Unfortunately, under the new regulations, that's no longer the case. If you are an official with authority, you are always on, and that's what accounts for the distinction under our policy.
And I'll just add from a community perspective, going forward when we have these events, I recognize how it will feel, even personally, as one of the always-on officials with authority, how it can look at an event when people begin to share if I were to walk away. But I want you to know that it's so that if the Dean of Students walks away or if Chancellor Grasso's there and walks away, it's out of respect for you. It's not for a lack of caring. It's to create space for people to share without having to worry about matters moving beyond how they want them to move.
That's good information. Question about our faculty ombuds. Is that person available for staff members too?
So the faculty ombuds is available for faculty members. The university is in the process of building out a staff ombud service. It's still in its beginning phases and isn't available to the Dearborn campus yet. But I will say that for staff, we do have the FASCO office. And I've worked with FASCO a lot. They're very skilled at what they do, and they're very knowledgeable about OIE procedures. So I wouldn't help or hesitate to reach out to them as a confidential resource.
Next question clearly is a sign of the times. So are there any special procedures or policies that have been modified in response to the COVID crisis? Because so many people are now working online and remotely, we're not in that traditional campus setting. And so have there been any changes there, or are there any considerations, surrounding this current pandemic situation?
Yes, I will speak to that. What we've tried to do is eliminate kind of descriptors that may have previously said in person. And look, we recognize that right now there really isn't in person. This is in person. A Zoom is in person. And so in practice, investigations are continuing. The work in this space is very much ongoing. Hearings are going on. They are being conducted remotely. And at least what we are finding thus far is that those participating in those hearings seem to like it better. And there are some reasons for that. When we have done these in person in the past, they're done in an office space. We try to separate the parties as much as possible, but there is always the possibility of a complainant running into a respondent in the hallway, going to the restroom, or just back and forth. When you are remote, you don't have that situation. The remote hearings have also enabled us to do more in terms of scheduling, because there's not a travel time barrier for a lot of our hearing officers. So the feedback that we've been receiving is pretty positive. And I just kind of want to put this into perspective. I think in calendar year 2019, at least on the Ann Arbor campus, we did somewhere in the order of magnitude of roughly 15 to 17 hearings in total. In the month of June, we did 8 hearings alone, and all of those were done remotely. It is working, at least that's what we've been finding. And we are sensitive to those issues and considerations and have been working with the parties to try to accommodate them the best that we can.
Thank you. Interesting question. As a student employee, in the event, if an event were to happen while I was on the clock and I decided to report it, do I go through the process as a student or as an employee?
So I would say, oh, I'm sorry. I think I was listening to the question in a different way. Do they mean if they're alleged to have engaged in behavior? Is that what the question says?
No, I'll read it verbatim. As a student employee, if an event were to happen while I was on the clock and I decided to report it, would I go through the process as a student or as an employee?
Okay, so which procedure would apply depends on who the respondent is. So if they're the complainant as a student, it would depend on who engaged in the behavior towards them. If that question is saying, if I am, to have done something, then we would actually look at that situation to see where they were acting more in their employment role or in their student role. Since they use that term on the clock, it sounds like maybe they were at work, and it would be an employee procedures case. But believe it or not, we anticipated this, and that a conversation about those issues that's written into the procedures. But we always look to see how the person was engaging within the community, meaning the respondent, how the respondent was acting, to determine which procedure would apply. If that didn't answer, whoever asked that question, if that didn't answer, please reach out to me separately, and I'm happy to give you more information. Okay.
All right, we just 2 more questions. I think this maybe was addressed, but it came up late, so maybe we didn't. It says there is no policy right now that covers employees against sexuality-based discrimination or harassment. When can we expect a policy like this to protect us?
So Um, I'm not sure how to interpret the question. We do have a policy that prohibits discrimination. This one prohibits discrimination on the basis of gender, gender identity, gender expression, sexual orientation, and gender-based harassment, which would encompass harassment on the basis of all of those. If this person, by using the term sexuality, if they're asking a question beyond that, then I'd like to talk to them to see what specifically they're asking about so that I can answer their question. So that's what we do prohibit. If you're asking beyond that, I would need to know a little bit more to tell you whether we had a policy that addresses it or not. So just please reach out to me.
Yep. Okay, great. Thanks. And then final question before we wrap up. And this sort of piggybacks on the one about the take back the night event type of thing. It says, can we review policy for who must report when a student discloses in a class discussion?
Yes, and so you can see my attempt at highlighting here. So this goes back to, again, what bucket you fall under. And so again, if you're an official with authority and you're teaching a class, so you're a dean or a department chair, you're always on. There are no exceptions. And so again, I would encourage you to tell your students at the outset that you have this reporting obligation. Maybe even put it on your syllabus. But then there are all other IROs. If you fall into that other IRO category, so for the most part, this is going to be the vast, vast, vast majority of faculty members who teach classes, then if someone communicates in the course of a classroom discussion that they have experienced sexual misconduct, you do not have to report it. That is an exception because unless you're an official with authority, you're not always on. It arises within the scope of your employment. And we have exempted classroom discussions, recognizing that there are various issues surrounding academic freedom and otherwise that we wanted to respect. Hopefully that answers the question.
And then Pam, will you put this presentation on your website? We had a request to see if they can access this at some point.
Well, first of all, if that person emails me, I'll send it to them right away. I would say that information very similar to this is on my website and will be added to my website. Whether it's this exact presentation or not, I don't know. But anybody who wants a copy of this presentation, I'm happy to send it to you. Just reach out to me. Perfect.
Okay, we are a little bit over. Any last comments from Chancellor Grasso, Patty, Pam? Anything to add?
I just want to thank Patty and Pam. I mean, we're very fortunate to have such talented and dedicated individuals working on this with us. And our goal is to make sure that we have a safe and welcoming environment for everybody on campus. And we're going to do everything we can to ensure that.
And I'd just like to say thanks again to all of the participants. There were a lot of you present today and everybody asked really great questions, and we just appreciate the opportunity to communicate this to you.
And I want to echo those sentiments and also say if you had a question that you didn't ask or a question that comes up later, I'm here for you. Just reach out and I'm happy to talk with you or respond to an email.
No, thank you for all the panelists. This was great information. I learned a lot, and you can tell a lot of work went into this. Very complicated, a lot of things to maneuver. So thank you very much. Thank you, IT, for making this work today. It worked very well, I believe. And with that, we'll end. Have a great afternoon. Thanks for joining us, and we'll be talking again soon. Have a great day.
Great. Thank you so much, everyone.
Bye-bye.